1966 ခုနှစ်မြန်မာနိုင်ငံတရားစီရင်ထုံးစာမျက်နှာနံပါတ်939ဒေါ်လှရင် N1 Appellants vs ဦးမောင်စိန် and two others respondents ဤစီရင်ထုံး audio book ကိုအထက်တန်းရှေ့နေဦးအောင်ခိုင်ဦးအထက်တန်းရှေ့နေဒေါ်ပြည့်ပြည့်ဖြိုးနှင့်တရားလွှတ်တော်ရှေ့နေဦးထိန်လင်းဦးတို့မိသားစုကစီစဉ်ဆောင်ရွက်ပြီးဒေါ်ယူပါစောမင်းမှဖတ်ကြားခြင်းဖြစ်ပါသည် Civil First Appeal before ဦးသက်ဖေ Judge ဒေါ်လှရင် N1 Appellants vs ဦးမောင်စိန် and two others respondents Code of Civil Procedure Code Order 41 Rule 27 Additional Evidence Admission after the appreciation of evidence on record to enable to pronounce judgment or for any substantial cause whether it can be exercised before the appeal is heard on merits. Hell, additional evidence under Rule 27, Order 41 can be admitted only when the court after the appreciation of the evidence on record as it stands requires it to enable it to pronounce judgment or for any substantial cause the proper time for the exercise of the discretion under the rule therefore is when the court finds on examining the evidence as it stands that there is some defect or lacuna apparent on the face of the record, it cannot be exercised before the appeal is heard on merits. Kasoji Isa vs. Great Indian Peninsula Railway Company ILR 31 Bombay 381 Pasodim, Taku and others vs. Le Moha, Taka and others AIR 1931 PC 143 at p.539 MAUNG vs. MAUNG SEIN AIR 1939 Rangoon 92 refer to Myin So for the appellants, MAUNG Myin for the respondents, Udape Judge. This order relates to the application by the appellants date the 19 April 1966 under Rule 27 Order 41 Civil Procedure Code to admit additional evidence by examining 1. Do Phwa Sein, who had not been cited in the trial court. The application is, of course, stoutly resisted by the respondents. Additional evidence under Rule 27, Order 41 can be admitted only when the court, after the appreciation of the evidence on record as it stands, requires it to enable it to pronounce judgment or for any substantial cause the proper time for the exercise of the discretion under the rule therefore is when the court finds on examining the evidence as it stands that there is some defect or lacuna apparent on the face of the record, it cannot be exercised before the appeal is heard on merits. The Privy Council in Kasoji Isa vs. Great Indian Peninsula Railway Company 1 has held that the legitimate occasion for Section 568, now Rule 27, Order 41 of the Civil Procedure Code is when on examining the evidence as it stands, some inherent lacuna or defect becomes apparent, and not where a discovery is made outside the code of fresh evidence and the application is made to import it, then in Pasodim, Taku, and others versus Le Moha, Taka, and others too, the above decision was approved and observed that the legitimate occasion for the exercise of the discretion is not whenever before the appeal is heard a party applies to adduce fresh evidence, but when on examining the evidence as it stands, some inherent lacuna or defect becomes apparent. See also MAUNG versus MAUNG 3, where it was ruled that further evidence is not intended to be ordered on special and preliminary application before the appeal on the merits has been had and the evidence as it stood examined by the court. In the present case, the appeal has not yet been heard, and the additional evidence, therefore, cannot be ordered to be admitted under Rule 27, Order 41, in the respect the application of the appellants fails and is dismissed with cause, advocate fees, Jet 17.